It is a great honor to introduce to you all to our next distinguished guest, Senior Advocate Sanjeeva Bhaskarrao Deshpande, Zonal Coordinator, Maharashtra and Gujarat Zone ABAP. Sir is a legal luminary of remarkable accomplishments, having served as the Assistant Solicitor General of India at Bombay High Court Bench in Aurangabad from 2014 to 2020. In recognition of his outstanding contribution, Sir was designated as a Senior Advocate by Honorable Bombay High Court on 16 February 2023. His legal expertise extends to various esteemed organizations, including the Pharmacy Council of India, the Accountant General, University Grants Commission, BSNL, Kendra Vidyalaya, Indian Railway and Central Board of Secondary Education. Additionally, Sir has an impressive portfolio of over 50 reported judgments to his name. He has also served as a special public prosecutor, securing convictions for nearly 25 accused individuals in Shivali Roy's case. Sir is a distinguished keynote speaker on a range of vital topics, including abrogation of Article 370, Common Civil Code, and IP laws in India, making him a true legal authority. I would request Sir to kindly come to the podium and apprise us with his illuminating words. Sir, please.
Dignitaries on the dais, and dear friends, it is indeed a pleasure to address such an august gathering comprising of very experienced lawyers as well as newcomers. I thank Adhivakta Parishad, Delhi Prant for organizing such a very good program and inviting me for this function. After the announcement of the Honorable Home Minister to bring 3 new laws, there were heated debates regarding the feasibility, necessity, and regarding the provisions in the proposed act. Therefore, the first question is that whether it was necessary to reform these laws or not, whether the criminal justice system in India is working to the satisfaction of general public, clans, and judiciary as well. In this regard, I am reminded by a satirical post written by Harishankar Parsaiji 2-3 decades ago, wherein he gave example of Mahabharat war, and he compared and said that if Krishna had not dissuaded Arjuna from waging a war, what would have happened? Then Arjuna would have been compelled to go to Kacheri. Then his brother Dharmaraj will have to arrange for the funds. And when the cross-examination is held, will Dharmaraj be able to withstand the searching cross-examination of a very experienced lawyer or not? And then the question, he said that in the meantime, there are so many adjournments that even a mighty Bhima will lose his weight and will look very frail. In this background, we will have to see and we will have to introspect whether the present criminal justice dispensation system needs revolve or not. If we go to certain other parameters also, it will become abundantly clear that according to the data released by NCRB in the year 2021, Indian prison population had 77% of under trials and only 22% convicts. While most of the under trials in prison are there for more than 2 years, out of 5,54,000 prisoners, 4,27,000 prisoners were awaiting trial, and out of which 24,000 and odd under trials were already in jail for more than 3 years. The occupancy rate of prison was 130%. So as against capacity of 100 bed or 100 inmates, there are 130 inmates in Indian prison. If we look at the pendency rate, then it will become abundantly clear that 302 matters are pending for the percentage is nearly 39%. So the situation is really alarming. Therefore, it cannot be said that the system was working and then the Honorable Home Minister decided to change the laws for any other reason. Therefore, at the outset, I congratulate the Honorable Prime Minister Narendra Modi ji and Honorable Home Minister Amit Shah ji for bailing the cat and trying to overhaul the criminal justice system. They both need to be congratulated on this aspect. Another aspect in the matter is that it is not that laws were changed time and again. In the opening session, it was pointed out that in the year 1834, there was a commission headed by Macaulay, and that drafted this present IPC. Then much water had flown from the Ganges water, and now emerging Bharat requires something different. And in that regard, if we see at the present Bhartiya Nyay Sanhita, the first notable thing that we will admire is that it is not only that sections are pruned or decreased, they are reoriented, reorganized. In the old IPC, many sections are there only for the purpose of definition clause. That is done away with, and by one section it is given. It is incorporated. Then after the formal chapters, Amit Shahji's proposed act has now devoted a separate chapter on women and children. In the earlier IPC, you will find that there was something different like offences against state, etc. I think this is the importance that the present dispensation is given to woman and child, and therefore this is not only just regrouping of the section, this is reorientation of the entire approach, and half of the population in India was given its due importance and due weightage in the new Bhartiya Nyay Sanhita. In the sections, there are many provisions made new. I want to submit, and as my colleague Anand also appeared before the Parliamentary Standing Committee, I also made representation before the Standing Committee. Therein I said that in consonance with the policy of the present dispensation to give justice to women, it is necessary that the earlier provisions in section 125 of CRPC, which was a secular provision which gave a right to women of every religion to be entitled to get alimony and maintenance amount from her husband. Later on, in the case of Shah Bano, the Constitution Bench of Supreme Court said that yes, it is necessary that this provision is equally made applicable to Muslim women also. Unfortunately, the then government succumbed to the pressure, capitulated before the communal forces, and brought an act in the year 1986 whereby Muslim women's right of maintenance was taken away. My suggestion is that in keeping it tune with the philosophy of the present dispensation, again the effect of earlier section 125 needs to be brought again. In my humble opinion, this is ADM Jabalpur movement for the parliament. The Supreme Court made a historic blunder in ADM Jabalpur. Later on, in poetic justice, the son of the author of ADM Jabalpur reversed that judgment, and it is no longer a good law. Similarly, the 1986 Act is the ADM Jabalpur mistake committed by Parliament, and therefore it is necessary for the Parliament, and I am hopeful that Parliament under the leadership of Narendra Modi ji will definitely seize this opportunity and will undo the historical wrong done to Muslim women, and it will usher us into gender equity and gender justice. And therefore, section 144 of Bhartiya Nyay Sanhita needs to be amended, and it being a new law, it can be clearly said that this will be applicable irrespective of whether the provisions of 1986 Act are in force or not. Now, one of the contentious issue raised regarding this Nyay Sanhita is regarding repealing of provision regarding sedition. If we compare the earlier provisions of section 124A, then, and if we read the new provision of section 150, then it will become abundantly clear that, no doubt, sedition is not there. But earlier, what was the provision? Whoever by words either spoken or written or by sign or by visible representation or otherwise brings or attempts to bring into hatred or contempt or excites or attempt to excite disaffection toward the government, that is called as sedition. And what is the new provision? New provision says, and the heading is that acts endangering sovereignty and integrity of India. That is very clear. And the ingredients are that whoever those things are there, by electronic communication or by use of financial means or otherwise excites or attempts to excite secession or armed rebellion or subversive activities or encourages feelings of separatist activities or endanger sovereignty or integrity of India will be punished. So these are very significant words. It can't be said that you are merely replacing the earlier provision regarding sedition and a new provision is brought. I am confident that everyone present in the hall is aware of the nefarious activities being undertaken by Tukde Gang, etc. Is it not necessary to nail them? Is it not necessary to bring them to book? Freedom of expression is a different thing. And assessing their activities on the touchstone, whether they are affecting and they are separatist activities likely to cause danger to sovereignty and integrity of India is a very welcome step, and I really welcome the provision in that regard. Likewise, for the first time, terrorist activity is clearly defined under section 111. Earlier, there was Prevention of Terrorist Activities Act that was repealed, then we have to take the help of UAPA Act. Now, the provision is that a person is said to have committed a terrorist act if he commits any act in India or in any foreign country with the intention to threaten the unity, integrity and sovereignty of India, to intimidate the general public or segment thereof, or to disturb public order by doing an act such as using bomb, etc., etc. Day in and day out, we are facing terrorist threats. I did not elaborate this fact particularly before Delhi people. You have also faced many terrorist onslaughts. And so it was need of the hour that a specific provision be made in the Bhartiya Nyay Sanhita on that count. Another very important provision which we may call as affecting the person indulging in love jihad is section 69, which says that whoever by deceitful means or by making promise, etc. And then explanation is very important. Deceitful means shall include the false promise of employment or promotion, inducement or marrying after suppressing identity. So if you try to enter into relationship with the person of opposite sex by disclosing your true identity, then we don't have any problem. But if you will suppress your identity, if you will hide your identity, then there will be definitely problem. And therefore I think that this is a very good provision. Similar provision regarding use of children for sexual exploitation is made in section 93. This is also a very good section. The entire philosophy of the new Nyay Sanhita appears to me that they have clubbed together allied subjects. Women and children is in one chapter. The offences against state is in another chapter. The offences against body is in another chapter. So wherever they were segregated, they have brought it under one roof, and this is a very welcome change. And therefore, I think that the central government has taken a giant step in changing the landscape of criminal justice system. It is really nice that Adhivakta Parishad, whose aim is to provide justice to the last person, has organized such a useful program. I thank every one of you for patiently listening me. Thank you very much.